Has anybody here heard me speak before? And you came back?
I don't remember what the topic was.
Okay, so a couple of you have heard me before. A lot of what I say will be repetitious. I'm going to cover primarily what the assessor does, what happens when you buy property, sell property, do new construction, and what the assessor's obligation is, and what your requirements are as a taxpayer as far as trying to fight with the assessor. So, how many of you ever dealt directly with an assessor's office before? You have. You have. You have. Wasn't a lot of fun, was it?
I got one good connection down in South Almani.
Okay.
That's
So-
a good experience because we want somebody.
Yeah, if you know somebody. I happen to know a lot of people in the LA County Assessor's Office, not because I worked with them, but because I've just developed relationships with them. I spent almost 17 years working at the Ventura County Assessor's Office. I've been a property tax agent for about almost 9 years now. So I've got quite a bit of experience in property taxes. So the assessor is obligated to revalue property whenever there's a change of ownership or new construction. Those are the two instances where they revalue property. So most of you are realtors. So most of you know when people buy property, they're paying their sales price. How many of you have heard this expression before? The assessor is obligated to accept your purchase price when you buy property, and that becomes your taxable value. Anybody ever hear that before?
Not true.
You have? It's not true. The reason it's not true is because they're required to enroll what's called fair market value. There's a presumption that the sales price is fair market value, but they're not obligated to enroll that value if they have evidence that you would have brought more in the marketplace than what you actually paid for it. Usually, if you're paying below market, it's because there's some kind of a condition issue with the property. And if the assessor doesn't accept your purchase price, you'd have to file an appeal, and you'd have to go ahead and fight with them regarding condition. I'll give you an
Make sure you take pictures.
Take pictures, yeah. I'll give you an example of one client that I had. They're in Beverly Hills. They paid $5 million for a house that was listed on the open market. And the assessor did accept their purchase price of $5 million. But one of the first things people do when they buy a property of that level is they do a remodel. They remodel the kitchen, they remodel the bathrooms. They started undergoing their remodel. And when they started their remodel, they discovered that there was some bootleg construction done at some period in time. And they're like the fourth or fifth owners of the property, so you can't point your finger and say the last guy did it. It might have been there for 30 years. It cost an extra $1 million just to remodel the house because they had to shore up the construction. If they had known about that, they would not have paid the $5 million. I took that to the Assessment Appeals Board, and we got it reduced by about $900,000. So it was dropped down to about $4.1 million, saving him about $12,000 a year in property taxes, yeah. A case that I have right now, and one of the other changes of ownership issues is when the owner of property dies, they are no longer the owner. Their beneficiaries become the owner, or whoever inherits the property from them. So at that point in time, there is a change of ownership. So what happens in that case is you don't have a purchase price. So the assessor is at liberty to make a determination based on their opinion what the value of that property is. I've got a client right now, also in Beverly Hills. They had a small strip mall. Their mother died in 2021, I think it was. And they went to a broker right away. The broker recommended that they list it for $4.8 million. They thought they could get more for it, so they listed it for $5.5. The highest offer that they received was $4.5. The assessor enrolled $6.3 million. It's a lot more than what they were even asking for it. I provided them, after they did the reassessment, you get your notice of supplemental, and you have 60 days for an informal review or to file an appeal. I requested the informal review, but I also filed the appeal because I didn't want to miss my 60-day statute of limitations. I gave them their marketing brochure. I gave them 3 of the offers that range from 3.5 to 4.5 million, and they refused to even look at it. We had our first hearing, I say first because it got continued, about a month ago, and they agreed to take it down to what it was marketed at, 5.5 million. But they wouldn't budge off that. We end up getting a continuance. They're going to take another look at more of my data and see what they come up with. One of the issues with that property is there's also a dry cleaner on it. I don't know if anybody's familiar with working with dry cleaners at all, but when you see a dry cleaner on a property,
EPA.
contamination. Even if there's no contamination at the time, I've had situations back when I worked for the assessor's office where somebody was trying to sell a strip mall that had a dry cleaners on it, and it had a clean bill of health 20 years ago. The bank insisted on doing another review. They found contamination. The bank would not loan. So they end up doing about a 30% reduction on the sales price just to get somebody to buy it, cash. That's some of the issues that come up. Once you get a notice of supplemental, does everybody know what a supplemental is? Anybody not know what a supplemental is? Okay, y'all know what supplementals are, good. Once you get the notice of supplemental from an assessor's office, you have 60 days to file an appeal. So if you were to get a supplemental notice, let's say back in December, you had until February to file your appeal. If you don't file your appeal, you have 4 years from the first July 1st of each year to file on the base value. So what happens is, as of July 1st, your base value gets enrolled for the first time. You'll see it on your October tax bill. In LA County, you have until November 30th, starting July 2nd, till November 30th to file on your base value or a decline in value. Ventura County, you only have until September 15th each year. There's about 12 counties that give you until September 15th to file an appeal on your annual value or your base value. The difference is the counties that send out annual notices right around August, those counties, you must file your annual appeal no later than September 15th. The counties that don't send out the notices, you have until your November 30th date. But on your base value, if they don't accept your purchase price, or if you think it's too high because, like I described, that house that had that bootleg construction, you have 4 years to file your appeal. If you don't file your appeal within that 4-year period, then whatever base value the assessor enrolled stays. If you miss the first 2 or 3 years, then the year that you file the appeal, that's the year that the reduction will begin, if you're successful. And you will not get back taxes from those previous 3 years refunded to you. It'll start with the year that you filed the appeal.
How do they calculate the supplemental? Because that's one of
Okay.
the questions that the clients ask me. And I'm like, you know what, I don't know how they.
Well,
I know they send you a bill, but I don't know how they
First off, it's based on the regular tax rate that you get on your normal tax bill. So the average is about 1.2%. I've seen them as low as 1.08%. I've seen them as high as 1.24%, but 1.2 is a good marking point for it. So for every $100,000, you're going to pay about $1,200 in property taxes. Okay? What you have to look at is what is currently on the enrolled assessment. So as an example, let's say you've got an assessment of $200,000 for the current owners of the property. And you sell the property, or somebody buys the property for $1 million. The difference is $800,000. And it's calculated for the fiscal year. So if somebody were to buy a house today for $1 million on a property that's assessed for $200,000, you're going to get a tax bill, a supplemental tax bill, for the fiscal year 2024-2025, because that's where we're right now. Based on $800,000 times your tax rate, prorated, this is March, for April, May, and June, 3 months. But then you're also going to get a supplemental bill for the entire 2025 fiscal year, because the assessed value is based on what the value was as of January 1st. So the prior owner, the person that sold it today, their January 1st value is $200,000. So when the October bill comes out, it's going to be based on $200,000. So you're going to get a supplemental for the 25 tax year, entire fiscal year, for that $800,000 difference, to where you're going to end up paying taxes on the full $1 million for that fiscal year. Did that answer your question?
Did you have?
I have a question on that. So in that example, are they essentially paying a double tax on the 25 year, because they also have their property taxes that will roll around on 2025? But you just mentioned the supplemental will also be calculated on 25. So the first year or the second year of ownership, it's double taxation?
No. And the reason for that is because your the 25 tax bill that you receive in October on a home that you buy in March is based on the prior owner's value of $200,000 as of January 1st. You paid $1 million for the home, so your difference is $800,000. So the supplemental is $800,000
For the first year.
for the first fiscal year.
But then
So-
2025, if we get another valuation,
Oh.
aren't they also paying property taxes already included?
The bill that comes out this coming October is for the 25 year. And the supplemental will cover the 25 year also. 1 million minus the 200,000 that's already on the assessment. So your supplemental will be based on an $800,000 valuation, even though you paid 1 million. So your 26 bill will reflect the full $1 million. Clear?
I think so.
Okay.
I guess what he's probably trying to say is the difference between the two is the supplemental.
Yes.
So that's
Yeah, so sales price minus what the assessed value is for 2025.
And supplemental bills are the responsibility of the buyer, not the impound account. Because my client just called me a couple of weeks ago and says, I got my supplemental, but I don't have the money. I go, your money is in the impound account. So I got on the phone, we called the lender, and I told the lender, you need to give him the money so he can pay the supplemental. And we got it done, and they gave him the money to pay the supplemental.
Yeah. When you look at the sales
Because
contracts,
it's not going to come out of the impound account unless you call that bank.
when you look at the sales contracts, big all cap section, I don't know how many pages the sales contract is. There are about 12 pages in there. And I don't know how many numbers there are. It used to be number 27 or 28, all caps. Buyer is responsible for the supplemental. And I don't know how many years now, they now have a disclosure in title saying you're going to be responsible for the supplemental. So the buyers have to sell.
The problem is that the assessor is so slow because my client, it was 9 months ago I sold that house. He's barely getting supplementals now. So even the last, December bill was not updated. So, you've got to really study the tax bills.
Yeah.
That's why you just need to tell them they're gonna have a supplemental.
And a lot of people don't tell their
Yeah, I'll give you one quick point, then I'll get to you. Yeah, what happens is the reason why the assessor is so far behind, it's part of the process. Right now, for them, the world stopped on December 31st. They have to get all sales and new construction items that occurred in last calendar year completed by June 30th of this year. So they're still working on everything that happened in calendar year 2024. They will not touch 2025 calendar year until July 1st. But what they also do is everybody goes on vacation in June and July, end of June and July, because they're on a vacation blackout for about 4 months. They also will not do anything for a while because the assessor is reshuffling where everybody in the office is working. So they often don't get started till September, at least in LA County. They won't do hardly anything from the end of June till about the middle of September.
I was just going to say back to your point is that the problem, I'm a lender, so the other element that gets thrown into it is that lenders have to refund impound account overages now, right, for years. So clients will get this large check sometimes in that first year, and the assessor hasn't gotten the file yet. They spend it, they don't realize that's your money that you're gonna need to pay supplementals and hang on to it. So, it becomes a big, I call it design to confuse. It feels like it at times.
Yeah. Yeah, people don't understand the difference between the supplemental and the impound account. The supplemental is a one-time, it might be two bills, because anybody who buys right now, they get two supplemental bills. It's a 3-month bill for the 24-25 tax year, and then they get a full year bill for the 25-26 tax year.
So I guess that was my question that she had, where I was thinking of double taxation, because normally the lender's already collecting an impound, but the impound is not for the supplemental, correct?
Correct.
So then there is sort of a double taxation where the supplemental for 25 needs to be paid, but also their property tax also needs to be paid for 25, right, from the impound.
Well-
Usually if I hadn't called that bank, they would have had so much money in there, they would have refunded him later, but he still has to pay that supplemental now. So I got the money, the bank to give him the money to pay the supplemental.
They pay taxes once, and the escrow account is going for future tax bills.
Got it, okay.
Yeah. Yeah, the impound account goes toward next year's regular tax bill. So,
I'm not sure they're gonna cover this later, but if a property is in a trust and it stays in the trust, would that avoid any taxes?
Nope. Nope.
when a property owner dies, their property is reassessable, unless it's going directly to their spouse or a co-tenant. There's a special co-tenancy law. Also, when I say spouse, it would also include a registered domestic partner. Okay?
And a child,
No,
if it's
No.
unoccupied.
no. I'll clarify that in a second. Okay, a co-tenancy law, I remember the first one that I took down to LA County, the person that I was talking to, when I gave him all the documents for it, goes, well, what do you want me to do about it? I said, well, it shouldn't be reassessed. You guys reassessed it. Well, why not? I said, because they were co-tenants. Because I never heard of that. And this is LA County. It was in 2018, and the law passed in 2012. It was an answer from our legislatures to the gay marriage issue. Whether it was legal or not legal, it went back and forth for a few years. So they created the co-tenancy law. The co-tenancy law is, if there is exactly 2 people on title, and they've been on title for more than a year, they are beneficiaries of each other. I.e., let's say you and I buy property together, we're both on title, and we go on title as joint tenants. By law, when I die, you get my half. When you die, I get your half. Or if we set up trusts where I name you as a life tenant, and then my son gets it, you name me as a life tenant, and then your children get it upon my death. Okay, we're life tenants, but we're co-tenants. We're on title, and we both live there for at least 1 year. And that the ownership ends due to death. So there's those 3 requirements. Must end by death, primary residence of both for 1 year, and both on title for 1 year. And both residents at the time of death.
How do you prove primary residence?
Voter registration, bills, driver's license. I prefer voter registration over anything else.
And homeowner's exemption on your tax bill. I just had a client.
Eligible for a homeowner's exemption.
If you're not knowing,
Yeah.
if she didn't have homeowner's exemption on her tax bill, they denied her. In Ojai, she lived in Ojai.
You're not required to have your homeowner's exemption. You're required to be eligible for it. No requirement that you have to have it filled out.
Just eligible.
Right. You might be thinking of parent-child, but we'll get to that.
It was my client because she was lived in Ojai and she was transferring her taxes back to Ventura, and they said, no, you don't have a homeowner's exemption. That's not your home. She was only there for a short time.
Oh, so she was going to Glendora.
From Ojai. She was
Okay, so LA denied it. I believe that.
LA denied it.
I believe that.
Yeah,
But
LA denied it.
I would fight them.
That you could, as what you do, is that
I'd have to take a look at everything, but yes.
You probably could.
Yeah.
Probably could.
But that's what the co-tenancy agreement is in the co-tenancy law. So under that situation, there would not be a reassessment, but it has to be exactly two people on title, okay? But back to your question about the trust. If it's in a trust, does that avoid the reassessment? The answer is no.
If it stays in the trust.
No. Okay, the answer is no. The most common thing, how many of you ever sold property where the property was in a trust that belonged to the parents, but the parents had passed away 1, 3, 5, 8 years earlier? You've been to one of my classes before.
I have.
You have too. Okay.
And
So,
previous, I filed a Proposition 58, which no longer exists.
Right.
But
So-
now they get screwed because of Proposition 19,
yeah.
they all voted for this.
Tell you what,
They
why don't you,
made a big mistake.
you come stand up here.
I know, don't get me on my soapbox.
So what happens is, upon the death of a property owner, you're required to notify the assessor within 150 days. If you don't, it's not a big deal. There's usually not a penalty for it. But what happens later? Okay? Let's assume, and I've had a lot of clients like this, somebody died in the year 2000. I've had 24-year-old deaths, and I just got a call last week where mom died in 2000, dad died in 2005, and they never took it off title. It's still in the name of the parents' trust. Fortunately, these people did file their parent-child exclusion. So at this point in time, the assessor is aware that they own the property, and they could file a deed right now transferring it to their names. There'd be no reassessment. It'd just be called a correction of title, non-reassessable. But let's assume they didn't file their parent-child exclusion back in 2000 and 2005. So they're sitting here right now with these two properties in their parents' trusts, and they go and sell the properties. When they sell the properties, it's going to say mom and dad's trust to the new buyers. And the assessor is going to look at that and say, wait a minute, we have the trustee as mom and dad, but they didn't sign the deed. Oh, look, here's their death certificate from 2000 and 2005. We can go back to 2005 and reassess them. They're required to, because that's when they died. Statute of limitations, though. Let's assume for a moment that I did correct title and I did notify the assessor, but the assessor did not reassess the property. They have 4 years worth of back taxes to collect. They still have to go back to the year that the property changed ownership, but the statute of limitations on collection of back taxes is 4 years. In the case where we did not notify the assessor, they can collect back taxes for 8 years. In a situation where it's owned by a legal entity and they didn't report a change in control or change of ownership of a legal entity, that's LLCs, partnerships, corporations, no statute of limitations on how far back to collect back taxes. In 2016, working for the Assessor's Office, the Board of Equalization discovered a change of ownership on property owned by a legal entity in about 5 different counties of the state in 1982. So they got tax bills all the way back to 1982. I've had several people call me complaining because they got tax bills, saying like 2018, 19, 20, where people got tax bills dating back to 2000. Because what happened was dad transferred properties into a legal entity. Dad died within 2 years. They didn't report it to the state. They sold one of the properties in the name of the legal entity. Then they discovered dad's death. He was original transferor. They had to go back to 2000 on all the other properties, plus that one, and issue back taxes. I'm going to start talking a little bit about her Prop 19 parent-child issues and about base value transfers. So, in the case of somebody where the property is still in the trust and the parents died in 2000, 2005, 2015, they still qualify for the parent-child exclusion under the old law. Prop 58 is what they called it. So if they sell the property and the assessor discovers the death of the parent, they send out the tax bills, you have 6 months to file your parent-child exclusion. But the assessor is going to mail the tax bills, and they're unsecured now, to the last known address, often the parent's home. How many of you ever tried to forward mail from an old property? How long does it take for you to get that old mail? Do you always get that old mail? So if you miss it and you never even see those unsecured tax bills, those unsecured tax bills follow the trustee of the estate, often one of the children, and they don't discover it until they go out and buy their own home, and they find a lien against them personally from the tax collectors, or they go to refinance their current home and they find a tax lien. Sometimes tens of thousands of dollars. The biggest one I've seen is in the $80,000 range. But you're going to have to pay those. If you didn't file that parent-child exclusion within 6 months of selling that property, upon discovery and reassessment, you're pretty much screwed. Now, under the old law, you did not have to move into the house. Under current laws, if the child doesn't move into the house, they're not going to qualify for the parent-child exclusion. And the parent-child exclusion is not as good as it used to be. 3 requirements for getting the parent-child exclusion now. 1, it had to be the parent's primary residence. 2, a child must move in to the property within 1 year. And 3, they must file the homeowner's exemption. That's the only requirement that the assessor has on you to file the homeowner's exemption, is when you're getting the parent-child exclusion. Must file it within 1 year. Must move in within 1 year. Must be the parent's primary residence. If it wasn't the parent's primary residence, you're not going to qualify for a parent-child exclusion. If you do not move in within 1 year and have proof of it, you're not going to qualify for the parent-child exclusion. Think about probate. I mean, grandparent to grandchild exclusion is treated exactly like a parent-child exclusion, provided the grandparent's child is deceased. That way it can pass straight down to the grandchildren. But their other parent, the one that's not a direct descendant of the grandparents, also must be deceased. Or the marriage, they have to die too. Yeah, My Pillow's making a fortune off that. The other birth parent must also be deceased, or their marriage had to end in divorce, or after the biological parent died, they got remarried. Yeah, so there's 3, yeah. The biological parent had to have gotten remarried after. So you have grandparents, direct lineage parent, and grandchildren.
Yeah, this one's
The direct lineage parent must be deceased. I had a case where their parent was in a coma and had been in a coma for 17 years. They did not qualify.
Both parents or just one parent? Or both?
Well, this one parent, the other parent divorced them because they were in a coma. Okay. So you have the direct lineage parent has to be deceased, and their spouse / biological parent of the child has to be deceased, divorced the parent before they died, or remarried after they died. Now, in situations where you have the direct lineage where the biological parents were never married, then no divorce and no death has to occur. So if they weren't married, it's okay.
Yeah, but he was saying something about, let's say, for example, I'm gonna give you an example real life.
Does it involve a pillow?
My mom has a house, and she has her living trust. I told her, do not leave me anything, leave it to my child. So she put my son as the beneficiary, not me. So meaning that for him to be able to be owner of that, I have to die too?
Yes. Well, no. Not for him to own it. Not for him to own it. For him to qualify for the grandparent-grandchild exclusion.
Oh,
You know, so not for him to own it. For him to qualify for the exclusion.
I have that.
Yeah.
Yeah, because you know what?
Do you have that in your plans yet? Have you-
No, then he can pay the taxes then.
Because my friend just called and his granddaughter, you know, the grandparents stayed at the house, and the lender told them, oh, you can just file this, because that lender should be in this class, because her mom is still alive, so she's not gonna, you know, get the grandma's taxes.
Exactly,
That's why I asked her that one.
Yeah.
I told her, call the assessor, because I don't trust it anymore, there's too much
Yeah.
information out there.
Yeah.
So basically, you have 3 levels, that middle level has to be gone some
Yeah.
way.
All gone. All gone. And the grandchild also could not have qualified for a parent-to-child exclusion at any time either. Yeah, so that's another thing that people don't think about. You know, let's assume for a moment the parents had granted them their primary residence, then they don't qualify for one from their grandparents.
When was this parent-child reinstated? Because I know it had gone away after Prop 19, but it's now reinstated, right?
It never went away.
Parent-child exclusion started in 1986 under the old law. Prop 19 changed it.
Oh, it changed it, or
Yes.
is it eliminated? I thought it had-
It changed it drastically. Prior to Prop 19, you were not required to move into the property of the parent's primary residence. You could inherit it and keep the tax base. Plus, income-producing property, you could inherit up to $1 million worth of assessed value. So if your parents also owned a strip mall or a couple of rentals, as long as the assessed values did not exceed $1 million, there'd be no reassessment.
That's where we got screwed, big
Yeah,
time.
yeah. So what happens also under the current Prop 19 parent-child exclusions are the assessor is still required to reassess the property at fair market value. So let's assume for a moment the parents have a property, it's assessed at $400,000. And the fair market value is $1.2 million. Parents die, leave the property to their kids. Kids move in within a year, file the homeowner exemption, file the parent-child exclusion claim. They have a new base value established by the assessor at $1.4 million. Fair market value. Or $1.2 million is what I said, fair market value. The assessed value is $400,000. The difference is $800. Your taxable value with the parent-child exclusion is going to drop down to that $400,000, your parent's old base value. But your base value on the property is going to be $1.2 million, and that factors every year just like your regular property taxes do. Now, take another example. Still, your parents are assessed at $400,000, but fair market value is $2.1 million. Your new assessed value is going to be $1.1 million because the maximum they can take off the fair market value is $1 million. They just adjusted it. It's like $1,056,000 now. It adjusts every other year, but I'm just going to use the $1 million as a round number. Does that make sense? You're shaking your head, let's okay. Okay. And all income-producing property does not get an exclusion now. But you can appeal the value that the assessor determines to be fair market. I've got several cases going on right now. One in San Francisco County. They had a date of death appraisal at $1.2 million. Their current assessment is $500,000. Their parents' old assessment was $300,000. But the assessor determined market value was $1.5 million. That's why it's assessed at $500,000. If I'm successful in getting it down to about $1.1 million, then they're going to save about $3,000 a year more. I've got one down in Manhattan Beach. The assessor determined that the value was $4.3 million. I'm arguing that's only about $3.5 million. Their current assessment is $3.3 million. But if I can get it down to the market value down to 3.5, it'll go down to 2.5. It'll save them another $8,000 a year in property taxes plus.
And how can you, like, put in an appeal? Let's
You
say-
file the appeal. You have your 60
You can do it
days.
yourself, you can do it yourself, like I said.
Anybody can do it themselves, yes. But do you know all the tax laws? Do you know how to tell the assessor they don't know what they're talking about?
We have to go.
Yeah. No, but that's what I do for a living. I make my living more off of appeals than I do off of anything else. Questions?
Going back to co-tenancy law, is there any overlay between common law, like someone living together for over 7 years?
If they're not both on title, they're not co-tenants. Yeah. Now, I've got a client right now, and it's a parent and child. Dad wasn't doing well. He added his son to title as a joint tenant, doesn't have a trust, and if I remember the right date, it was on April 9th, 2021. He added his son as a joint tenant. They did not record the deed until 3 months later, but the deed was executed and notarized on April 9th. That's legitimate. That's the actual date of the change of ownership. The assessor works under the presumption that the recording date is the date of change of ownership unless you fight them with it, okay? And that's easy to do. That's one of the easiest things to do. Dad died April 21st the following year, 2022. So they were co-tenants. Son was on title and living in the house. He'd been living in the house for 12 years. But they were both on title beginning April 9th of 2021. Dad dies in 2022. And the assessor won't give it to him, the co-tenancy law. They said, no, he has to file for the parent-child exclusion. I've got a letter out to the BOE challenging that because 2 counties allowed me to do it. LA County's not allowing me to do it. So the Board of Equalization is going to have to come in and give me a letter saying what they can and cannot do. But they also came out with a very recent letter. Actually, it was a little pamphlet, Taxpayers' Right thing.
Trying to reassess that property?
Well, they did. But I'm trying to get them some refunds on it. But the BOE came out with a pamphlet that said, hey, if 2 brothers own home together and they're both on title for at least 1 year and one of them dies and they're beneficiaries of each other, then it's not reassessable. Well, why is it okay for siblings but not for parents and children? So that's what I'm trying to clear up.
Question on that one, that example, the father adding the son, wouldn't that have been a bad idea because adding the son would have triggered the reassessment?
Okay. If, I don't know where he got his advice, but it was good advice. So he's asking if by adding the son that triggers a reassessment. It depends. If I own property and I add you and I just say, what's your name? Chris. So Chris and I own a property and I add Chris. We now both own the property, but I add her as a tenant in common. That creates a 50% reassessment. Ooh. But if I'm the only person on title and I had her as a joint tenant, then there's no reassessment. God, her eyes went like this. So what happens is you're creating a joint tenancy after you already own the property. I would be what's called an original transferor. And it's abbreviated OT, and these are the actual terms used in the Revenue and Taxation Code. I am what's called an original transferor. She would be an other than original transferor, or an OT-OT. So as long as an OT remains on title, there's no reassessment. And as long as the joint tenancy is not severed. So I can take her off title and still not be reassessed. As long as what would happen was we create another deed where Kent and Chris transfer to Kent as sole and separate property. I'm the original transfer, no reassessment. But Kent transfers to Kent and Chris as joint tenants, no reassessment. Kent and Chris then transferred to Chris as sole and separate property, 100% reassessed. You have to be very careful with joint tenancies. I get calls from attorneys all the time asking, why did this get reassessed? I said, because you severed the joint tenancy, a severance of joint tenancy. Let's assume for a moment I own property and I add Chris and, what is your name? Max? Matt. So Kent transfers property to Kent, Chris, and Matt, all as joint tenants. No reassessment, but we're all equal owners. That's one of the requirements of a joint tenancy. We all own 1/3 of the property. If I transfer the property to my trust, just 1/3 of it, it severs the joint tenancy, we get a 66% reassessment. If you sever the joint tenancy and you transfer to your trust, 1/3 goes into your trust, 1/3 stays with me, your 33% gets reassessed, but our joint tenancy is still intact, so our 66% does not get reassessed. Then I transfer mine to a trust, and her 33% gets reassessed. So it depends on who severs it and how much of it gets severed. If I sever it, everything that I don't own gets reassessed.
I guess same scenario that you were just talking about, but let's say the joint tenants were also a part of receiving the property in the trust.
Okay, a joint tenancy, trust cannot be part of a joint tenancy. Wow. Yeah. A joint tenancy will not include a trust. If you add a trust to a joint tenancy, it's not considered a joint tenancy for assessment purposes. Anything else?
I just wonder, is there a way to dispute that where it's the parents both pass, it's in a trust, and they leave the property to the son and the daughter, and then one buys out the other one, they don't get to assume the other one's tax, they get reassessed half. 50%.
Okay. So her question is, what happens when property is held in a trust and the parents die and it goes to two children?
One's gonna move in.
One moves in. Okay, if one moves in and they both remain on title, then it still gets reassessed upon the parent's death, but they still qualify for the parent-child exclusion also, as long as one lives there. But if one child buys out the other child, they lose half the parent-child exclusion and get reassessed another 50% at that time.
How about now with the Proposition 19?
That's under Prop 19.
Even Prop 19,
Yeah.
then it's still split it?
Well, what happens is, and this is pre-Prop 19 also, if one child wants to inherit the parent's property without reassessment or to qualify for the parent-child exclusion, and the other children want money, you have to do something called equalizing the distribution. To equalize the distribution, you need to get a third-party loan to the trust. You get that? It goes to the trust. So the trustee will take out the loan, and you fund the trust account with the proceeds from that loan. And you take, let's say there's exactly 2 kids. You take enough cash to cover half the value of the house and distribute that to one child. And the child that's keeping the house, they get title to the house, plus they assume the debt from that third-party loan. So let's say it's an $800,000 home. They put they get a $400,000 third-party loan to the trust. The trust account now has $400,000 cash in it. They also have debt of $400,000. $400,000 goes to the one child that doesn't want the house. A house worth $800,000 goes to the child that's keeping it, plus a $400,000 debt, so they're only getting $400,000 equity. That makes sense? But and they get to keep the property tax. They get to take, well, no, it's still a reassessment. They get to qualify for the full parent-child exclusion. Yes.
Is there any way to avoid a tax reassessment with properties in the trust?
No, they stay alive. Well, they don't die.
Well, if you're transferring it to your trust, there should not be a reassessment. I've got a couple cases like that right now. Somebody just transferred their property to a trust. They were being assessed for $100,000. Now they're being assessed for $1.6 million. I'm going to fix that for them.
You know,
Okay.
people are giving misinformation. I had somebody ask me, somebody died like 3 years ago, and the property was in a trust. I go, "Why don't you pay taxes?" "Yeah, you do, because as soon as they find out they're dead, they're going back 3 years."
Yeah. But there are ways to avoid it, but they're complicated.
My
And,
mom got
and it's not always cost effective.
just for putting her, the property in a trust. And I
Putting
called-
property into a trust does not change the fact that once the property owner dies,
Yeah.
it's reassessable.
No, but right now she's still alive.
Okay, then it should not be reassessed. It shouldn't have been.
I
You
called.
need a higher chance.
I
Do
know.
you see that in your hand right there?
Yes, I'm.
Yeah, that's my
putting all the
card.
information there in my phone.
I'll come back to you.
From a tax lens, I helped a buyer buy a 2-bedroom, 2-bath property, but there's 3 bedrooms on the property because they extended an addition to the garage. So it's 3-bedroom physically, but on paper, tax assessment, it was a 2.
Okay.
What do I tell my client?
Did they take a permit out?
Prior seller, no.
Okay. That you actually, okay. The assessor is required to discover also. So let's say they discover that there's a 3-bedroom there when it should be 2. There's let's say a 300 square foot addition. Okay. The assessor has to put that into their records. But they will note that, okay, this person bought this property with this illegal addition. They know that it's an illegal addition. They were willing to pay X dollars, and 99% of the time they do accept the purchase price, maybe 99.5%. And they'll go ahead and enroll the value that they paid for it with a note and a drawing, if they have it, when they discover it, of that 3rd bedroom and that addition. They will not share that with building and safety. It's illegal. I don't know how many times somebody from building and safety came into the assessor's office when I worked there with the taxpayer in tow. Because the taxpayer was telling building and safety, but we have this addition on our property, but we don't have any record of it. So they go to the assessor's office, and the assessor's office plops open their records because the taxpayer is with them. Says, oh yeah, we picked up this addition back in 1968. It's been there since at least 1968. And building and
They used to go door to door.
yeah, and building and safety will say, oh, okay, we'll grandfather it in. Maybe. They might want, the laws have changed substantially in the past 20 years about illegal structures. They used to just grandfather them. Now they'll send out an inspector, make sure it's up to code, make sure there's no. Yeah. And then they'll go ahead and make you take out a permit. And then that permit goes to the assessor's office, and the assessor goes, oh, we already picked it up, and throws the permit away. Okay?
What about if that client, X amount of time passes by, they want to sell it, still no permit has been pulled?
They should, the buyer should beware, and
New buyer or current owner?
the new buyer should be aware, and the current owner should make an attempt to get it legalized.
You know what,
Somebody over here had a question.
Unless you're in El Monte or Azusa, because Azusa City and El Monte City, you have to get
Back to
inspection.
the topic that you were talking about, doesn't the trust end when the parent dies?
Does the trust end when the parent dies? 90%, oh, more than that. Most trusts become irrevocable upon the death of the trustor. The person that writes the trust, creates the trust, who's benefiting from the trust, upon their death, the trust becomes irrevocable. And that's a very good point, because the R&T code is very specific. Property is reassessable when a trust becomes irrevocable, i.e. when the trustor dies.
So you would say, one of the children can actually take out a loan on behalf of the trust. But
If the trust allows it,
if
yes.
it's irrevocable, how could you make changes?
Well, that's why I said you have to get a third-party loan. How many of you have had on title and irrevocable trust and tried to get Bank of America to lend on it. They're not going to do it. Chase Bank will not loan to an irrevocable trust. Wells Fargo will not loan to an irrevocable trust. That's why you have to get that third party to go ahead and do financing for you to the trust, and the trustee has to sign it. But there better be a clause in the trust that allows them to do so.
So I thought you meant the third party had to be the person that was part of this trust thing.
No, third party,
But you're talking about the lending,
yeah, the lender is third party. They call them bridge loans.
Right, okay, yeah.
Mhm.
Thank you.
I wanted to ask more about, what are you finding in like all these ADUs and add-ons?
Oh, ADUs and add-ons,
stuff?
okay.
Just curious if you're running into more.
Yes, a lot of cities are doing amnesty programs on ADUs, accessory dwelling units. If it was built under the current owner, the assessor is required to pick up value for it to the current owner. If they bought it with that illegal structure, then the assessor will say, okay, it was included in the purchase price, typically won't pick up any value for it, but you better have some proof that it was there when you bought it. But the assessor is required to discover. So if they discover some illegal construction, they're supposed to put it on their records and they're supposed to pick up value for it.
Converted the garage, or they actually did it.
Yeah. Yeah, those are common.
Yeah, I just didn't know if there was.
Yeah. Yeah, and they have their own cost guides for that. They don't reassess the entire property. They only reassess the portion that is newly constructed. So the ADU, the garage conversion and addition. And they try to find comparable sales. Let's say you have a house let's think of a tract neighborhood where everything looks the same basically. And they've tried to find a couple of models that don't have additions and a couple of models that do have additions, and try to figure out what the market value of that addition is and add that when you complete construction.
And as an owner builder, is there a particular like square footage besides what the city will allow, but is there a square footage that you say keep with under, or it's going to propel you into a higher?
The assessor doesn't get into that. That's with your building and safety division. And the assessor doesn't care what you build or how big you build it. They're going to add value if they can.
Well, I meant the square footage part. I know some cities, if you get like combine the square.
That
footage
has
with the
nothing to do with the
house,
assessor.
Now with the ADU, you just are.
That has nothing to do with the assessor. They just pick up the new value for the new construction.
All right.
You have to get that through
Square
building and
footage is
safety.
Not so much as just what the value is. Is all they're going.
Their determination is what the value is. That's what they concern themselves with, is the valuation of the property.
If your property is still in the trust, but the parent's still alive.
Say that again?
If the property in the trust, the parent's still alive and the parent refinance the house, would it trigger?
It shouldn't trigger a reassessment. Refinances should not trigger a reassessment. Only upon the trust becoming irrevocable, i.e. upon the parent's death, should there be a reassessment.
If someone add, the spouse to the loan, because a lot of times, like, they only take not the loan, the title, because they take the loan only, like, let's say the husband, because the wife doesn't work or has kind of whatever. But then they wanna add, like, I don't know, a couple years after, they wanna add the wife. Does that reassess?
Transfers between spouses are non-reassessable, off or on title.
Okay, so adding the.
Adding a spouse does not create a reassessment, or a domestic partner. Okay, if you gift property to a sibling, whatever portion they did not own before gets reassessed. Parents, if they gift it to their children, if it's their primary residence and the child moves in within 1 year, it's still reassessed, but they can qualify for the parent-child exclusion. Anytime there's a change of ownership, there's a reassessment.
What happens if somebody dies and they don't report it? Do they always catch that when you sell the house? Or
Okay, so if somebody dies and it's not reported, then they're probably going to rot for a while. I'm thinking, right now I'm thinking of poor Gene Hackman. Yeah. Okay, so if they don't report it, what happens is the assessor goes on their merry way until they discover it.
But like, what happens if you sell the house? Do they catch it?
Okay, I talked about that a little bit. Yeah, so if the property owner dies and then the property gets sold, the person signing the deed transferring it is not the original owner of the property. So the assessor is going to notice that deed discrepancy, and they're going to try to find out who the owner was and when they died. I had a client called me, asked me why some properties that she owned in Ventura County got reassessed. And I started looking through everything. I called the assessor and I called my client back. I said, Rita, you died. My client's first and last name were the same as somebody else. They had a different middle initial. The assessor just ran the first and last name through their database and found all these properties that belonged to my client, and they reassessed. It was, I couldn't believe how difficult it was to prove to the assessor that she was still alive. Whereas that was Ventura County, the one that I used to work in. Whereas in LA County, I've gotten those things changed many times, where they assumed somebody was dead when they weren't. But if they do die, they are required to be reassessed, unless it's going to a spouse or registered domestic partner or the co-tenancy exclusion.
Here's a good one for a lender. My niece's son bought a condo in Laverne. My niece's boyfriend co-signed, okay? So now here, 5 years later, they want to remove him. And they go, oh, he was just a co-signer. Assessor says, really? Let me see his tax returns. He claimed the interest on the loan, so they denied him, and they took half of the property and they reassessed it.
Yeah.
Be careful if you have to co-sign. Make sure they're not claiming the interest, because they're going to reassess that property.
Two things that you guys need to be aware of. How many of you sold property to a young couple that haven't really established themselves, so they have to have a co-signer? And the co-signer is added to title? 90% of the time it's a parent. What used to happen pre-Prop 19, parents would go on title, 3, 4, 5 years later, the kids are more established, they refinance, get a new loan, parents come off title. And they send in, the title company sends in the preliminary change of ownership report saying this is the transfer between parent and child. They send out the parent-child exclusion form, they check the box, and they send it back, and they would not get reassessed. Well, parent-child exclusion only applies if it's your primary residence, the parent's primary residence when they come off title and the kids move in. Well, it's the kid's primary residence, but the parents weren't living there. They were co-signers. So now they're getting reassessed 50%. So what you have to do is have all your ducks in a row beforehand. Make sure that you have some kind of an agreement between the parents and the children that they're only co-signing. You're a lender, right? How often have you made that kind of a loan?
Yeah, we do now.
Yeah.
And the mistake he made, he claimed the interest on his income taxes, and the assessor is smart now. They're like, let me see your income taxes.
So now you have to have about this much paperwork to prove to the assessor, to prove to the assessor that they were just co-signers and that they had no beneficial interest in the property whatsoever. But the other thing that I'm getting a lot of, that's taking somebody off title. What if you're adding somebody as a co-signer? In LA, they reassess. I don't know how many different laws and court cases I've found challenging the assessor in LA County on this. And their explanation is, well, we have no way to track it. So we're going to reassess. When they take the co-signer off, we'll reverse it. That's illegal. You can't expect people to overpay on their taxes for 3 or 4 years until the parents come off title. It's illegal. And I fight with the assessor on these things all the time. Right now, I've got several cases in LA. This one, it's a sixplex. Man and woman got divorced. So a woman comes off title. As part of the divorce decree, he gets the property but had to buy her out. But he couldn't afford the loan on his own, so he added his son to title. And his son is on the loan. So I'm fighting with the assessor's office as a co-signer. My client didn't know his son was on title and didn't know his son was even on the loan. I said, well, here's a copy of the loan. Here's a deed of trust. Your son signed it. He did? So sometimes people don't even know what they're doing. They're just trying to get things done.
So for our
questions? More questions for, I have, oh, here, this question over there. You go ahead.
What's your question?
I'm not sure if this is gonna pass, but
Oh,
what
I
about?
got it. What about, what do you got?
What about the Altadena fires? How does the
Wait, okay, I can't hear you from up there.
What about the Altadena fires? How does the reassessment go?
Altadena fire. You want to talk about Altadena, not Pacific Palisades? God. Okay. For calamity. A calamity is something like an earthquake, fire, flood, whatever. Something that's an act of nature. So Altadena was a calamity. And you can fill out the calamity form within 12 months. And it's the simplest form. They even made it simpler. Prior to the Altadena fire, the calamity form in LA County had about 7 things you had to fill out. They modified it. Now you only have to fill out 4 things. Okay.
Quick question now, so how?
I haven't finished the answer on this one. Maybe I'll answer your question before, okay? So when property changes ownership, the assessor is required to reassess the property at a value, and they're also required to allocate value to the improvements and allocate value to the land. So each one has their own base value. That way, 10 years from now, if you were to demolish the house, they take off that improvement value, and the land value stays and has its own base. Same thing with a fire. They take off that improvement value. They don't touch that land value. So I looked up 2 houses in Pacific Palisades because of the discrepancies in values over there. You know, Altadena, most of the homes are between 1 and 1.5 million. Pacific Palisades, you've got homes up there that are $4, $5, $6 million, down as low as 3. But I found 2 houses that were side by side that burnt down in the fire. One of them was assessed for $300,000. $100,000 was to the improvement, $200,000 was to the land. The other house was assessed at $3.5 million, with about $1.5 million to the improvements and $2 million to the land, because they bought it more recently. Both of them had market value of about $4.5 million. So the assessor is required to take the property and look at the value the day before the fire. And then what is the value the day after? And they do a calculation based on what percentage was lost to the improvement and what percent was lost to the land. And they're always going to say there is no value lost to the land. And they'll just take the improvement value down to 0. So on those 2 examples I gave you, where one had an improvement value of $100,000 and one had an improvement value of $1.5 million, they'll take those off, and you're going to have about $1,000 a year reduction in property taxes for that property that was assessed at $300,000, and you'll get a $15,000 tax reduction on that one that was worth, or that was assessed at $3.5 million. Then, as you rebuild, the assessor is supposed to notify you every year or contact you every year and find out how close you are to rebuilding like for like. Now, granted, these are homes built in the 70s. You can't build a home like something that was built in the 70s and still make code or the market indicated quality. So as long as you stay in about the same footprint, they're not going to add any more value. So on that $100,000 home, or let's say they build the 2 homes at the same rate. So after 1 year, both of them are 25% complete. They're going to add $25,000 to that one house that was valued originally at $100,000 or assessed at $100,000. And they'll add, what's 25% of 1.5 million, 250, 125, $375,000 to that house. Then the next year you're 60% complete. So they'll take 60% of that 100,000 and put it on, 60% of 1.5 and put it on. Then when you're complete, they send you a supplemental bill for the 100,000 full value and the 1.5 million full value. You get to keep that base value, even if that value of the home, that new construction, might be $4 million cost.
But what if they're buying or even this
Okay,
behind.
so here, two things you gotta take into consideration. I'm not an expert on insurance, but everything I've heard is, if you tell your insurance company, or if you sell the property before you do it, if you sell the property before you rebuild and before you settle with your insurance company, the insurance company has the right to back out and say, we're not gonna cover anything. I'm speaking as a layman and based on rumors that I've heard.
Yeah, I
Okay.
just sold a lot over
Second,
in
though.
Altadena. So they
Yeah.
already got their insurance money, insurance already
Okay.
paid off the lender, and I just.
If you tell your insurance company that you're going to rebuild and then you get your settlement, then you decide not to rebuild, you change your mind, then you can sell the property, just that vacant land, and go someplace else. Now, the assessor had to make a determination as to what market value was the day before the calamity. You can take that with you and go to whatever property you build, and as long as you don't go over that, you can take your old base value with you. There is a small amount of appreciation that you can take with you also. It's 5% per year, but you have to do this within 5 years. And the maximum appreciation is 20%. So let's say you sell your lot for $800,000 on a property that had been worth $2 million, and you can take that $2 million and buy a $2 million house, $2,100,000 within a year, $2,200,000 within 2 years, etc., and keep your old property tax base with you. Is that what you wanted to hear?
Yeah,
Okay.
so they'll determine what the value was.
I guess we've been talking about property reassessments with higher evaluations, because whatever improvements, whatever. But what happens if you've got an area of buildings or properties, and ones are being bought up, renovated, whatnot, but one building in particular doesn't really do much, but they're assessing it at almost twice the value based on properties that have been improved.
So you're talking about all those areas that are being regentrified, basically? Yeah. A lot of places in LA, I'm thinking of Beverlywood area is a good example. I had a client near UCLA Medical Center. He bought a home in 2009. In 2015, he demolished it, and he built a brand new home. It was complete in 2016. The assessor added $1.3 million to it, okay, just for that new construction. They call it a pre and post. Pre and post valuation is when you say, okay, before the house was demolished, it was a 2,000 square foot 1950s home, and the average sales price was this. After they completed construction, it was now a 2016 built home, 3,600 square feet, and the average home is selling for X. And the difference is what the new construction value is. Well, they said it was 1.3 million. The difference between a 2,000 square foot 1950s built home and a 2016 built 3,600 square foot home, how much difference in value would you expect on that extra 1,600 square feet, all brand new home? Well, I drew comps, and my comps were saying about $650,000 difference. And his cost to build was $675,000. I took it to the appeals board and I got my number. So I saved him about $7,000 a year in property taxes.
And is there, for the sake of past years, is there any kind of recuperation?
As of the date that you filed the appeal is the date that you get the reduction.
I'm trying to calculate future property taxes for clients quite a bit, because we're setting up inbound accounts and qualifications. So can you tell me special assessments, are those based on value, or are they fixed?
No, ad valorem tax, okay, that's added tax due to the value of the property. So that is specifically your tax rate, whatever your tax rate is for that house, times the value of the house. Whereas the special assessments, those are voter-approved bond measures that have nothing to do with the value of the property. I've got a
Fixed element.
It's a fixed amount. It will sometimes adjust year to year, as your tax rate also will adjust year to year. But for the most part, those bond measures, until they retire, they don't fall off. I have a client up in Berkeley right now. It's a multi-unit apartment complex, rent control. His ad valorem tax, $19,000 a year, based on the old owner's value. His special assessments are $19,000 a year also. So he paid $2.5 million. The assessor said it's worth $3.3. So his ad valorem taxes are going to jump from $19,000. The prior owner's value at $1.2 million was $19,000. So his ad valorem taxes are going to jump to about $40,000 a year. But I'm going to try to keep them down to about 30. But he's still going to have those special assessments of another 19.
Don't they have like senior discount? Like, they should be able to-
Yeah, you stay in your house until you're a senior, you're still paying the same tax rate.
I would have to get it through art. Did that?
I think so. Oh, no, he has a question.
I had a client lose her home in Altadena. She said that it was approximately worth 2.5 before the fires.
Okay.
She said she engaged with the assessor, and the assessor said that she's only able to take her land value as her adjust her new purchase off of that land value.
They don't know what they're talking about. Okay. No.
So as far as, again, giving her some proper insight, I mean, other than giving her your information, you had mentioned a calamity.
There's a calamity claim form, and Prop 19 also covered victims of fire when they transfer property from, if they decide not to rebuild and find a replacement property. So, yeah, she can give me a call. I'll give her 5 or 10 minutes of my time.
Did anybody not have his business card? I should charge you. Where is
Any other last minute questions? There's a lot of people who don't have my card. Oh my God. You have a question?
Yeah, I have a question. I had some clients buy property.
Okay, co-tenancy law,
Yeah, so my clients bought a property, and what happened is as soon as they bought the property, like a month later, they broke up. So the one that left the relationship, he was willing to sign a
quitclaim deed,
Correct.
50% reassessed.
Okay.
Yeah, co-tenancy law only qualifies if one of them dies.
Okay, now, if something were to happen to the one that stayed, the other one is still on the loan. If he has a trust, does it protect the property? A quitclaim was signed.
That's a better question for him. She's asking me if a trust protects somebody from a loan. No. Yeah.
So what about the property?
Well, the property, again, when the trust becomes irrevocable, then it's 100% reassessable.
But would he be able to get the property?
It depends on how she wrote her trust. Whoever the beneficiaries of the trust inherit the property.
It's a gay couple.
Okay?
But I'm just wondering, would the trust protect the one that stayed?
If it's their trust, yes.
If the trust is written so that the property be sold and then the loan paid off.
Were they registered domestic partners?
They were together quite a few years.
Were they registered domestic partners?
No.
Okay. Then nothing protects you from reassessment. Okay. Upon death of the owner. What the trust does, it tells you where the property goes upon their death.
With the quitclaim signed, would it protect the property when it's sold that the asset
No. No, it's still going to have to be reassessed upon death. So this was another thing, this goes into divorces. I also belong to a group called Divorce Transition Professionals, people that help divorced individuals. a common thing that I've had to turn people away from. When somebody gets divorced, oftentimes you have a situation where you just sell the house, split the proceeds, and run on your merry way. If both people are over 55, they can take their base value with them, but you have to actually write in your stipulation who gets the old base value. It has to be in writing in order to qualify for the base value transfer.
Only one person takes it?
Only one person can have it.
I can split it.
Just one person gets it. The other thing that I see, when you have a couple that has children get divorced, oftentimes they will write in the divorce decree, okay, that spouse A will stay in the house until the youngest child reaches a certain age, at which time you will then sell the house and split the proceeds. Oftentimes, the person that's staying in the house will decide they don't want to sell the house, so they want to buy out their ex-spouse. 50% reassessable, unless you put into the divorce decree that after the youngest child reaches a certain age, you must sell the house and split the proceeds, or one can buy out the other. So even if it's 15 years later, after the divorce is finalized, they sell the house or one of them buys the other one out, it still qualifies as a spousal transfer because it was said in the divorce decree. Whereas if it was not stated in that divorce decree, 50% reassessment.
Wow, thought that same.
Yeah. If that doesn't save you guys some money, I don't know what will.
Let's give 'em